Yes,
my Lord. I appear with Mr. Dunwalsh for the appellant and my then Mr. Thomas for the respondent. I hope you don't mind Mr. Dunwalsh sitting there because it makes me together.
I don't. We don't.
My Lord, we have an application outstanding.
Yes.
For permission to amend the grounds of appeal. That part of it is how I would describe as precautionary in case of need, but we do move it. And an application to be permitted to rely on the supplementary skeleton.
Yes.
I signed about a week ago. And my Lord, my proposal, subject to your counter direction, is that I would formally make that application now, but deal with it in the course of my submissions, because some of the points I make would only, in respect of the application, would only become understandable when I describe what the point is that we want to run.
Yes.
And that way you can see whether it's part of the grounds of appeal as originally permitted or not.
Yes. That broadly accords with how we were proposing to ask you to handle it. You presented as a single precautionary application about the amendment to the grounds of appeal, but as you're aware, the arguments in the supplemental skeleton argument, which are presented as in some sense linked to the amendment said query, are said to be not open to you.
Yes.
And were prepared nevertheless to hear those arguments, Defendant SA, but we would like you to deal with, by way of anticipation, I think it'll help us, rather than wait for you to deal with it in reply, with the objections to its admission, which have been very fully set out in the parties' correspondence.
Yes.
I dare say you were into that anyway.
Yes.
Mr. Toms, you can live with that.
My Lord, we can. That was the position we made clear in correspondence, and we're happy to stick with that.
Yes.
Thank you.
Good.
And my Lord, you also mentioned a single application, but paragraph 1 of our draft order, I don't know how clearly this came out in the application notice, is for permission to rely on the supplementary skeleton. Paragraph 2 is to amend the grounds of appeal. So
Yes, no, I'm sorry. I agree. They are separately presented in the draft order, but you were describing them as if they were a single application.
So, my Lord, my client's basic argument that they do or wish to advance on this appeal can be reduced to 3 quite simple propositions.
Well, can I just ask one? Is live streaming is working, or it doesn't say it is. On a related point, no particular reason to believe you're doing this, but parties do sometimes arrange, particularly commercial parties, for there to be a transcript or even a one-day appeal. Is that something that's been done?
May I?
No.
It has not yet been done, but it can be done.
No, well, I think we would...
I think it will. I think it's better that it was done, and so I will...
Well, I mean, frankly, particularly in a case where there's complicated facts of this sort, although we have no right to ask you to do it, it does assist the court. And since you were saying you think it's a good idea, we will gratefully accept that offer, which I hope you're authorised to make.
Oh. Can I ask for ratification?
Yes. Well, if that can be done, what I presume is done from the live stream, then is it? I don't know what the mechanics are. Or you call it up in the old-fashioned way from. I leave all that side to you. We would be grateful for a transcript.
Not to me, my lord, but to somebody.
As I say, because where there's a lot of detail, it makes note-taking a little bit more. It's easier to take a summary note. Yes, thank you.
So, my lord, and this submission goes both to the appeal, if I'm permitted to run it this way, and to the application for permission to do it. My clients make 3. We submit quite simple propositions as to why the judge was wrong. And since objections taken to the supplementary skeleton, I will make these 3 simple propositions by reference to the original, called replacement skeleton in tab 3 of the bundle.
Yep.
And the first submission is that made in paragraph 7 at page 16 of the bundle. And the submission is that had...
Sorry,
Yeah, beg your pardon.
it will be helpful just to have it in front of us. I've got the skeletons and the judgment loose.
Yes.
Yes, so
So proposition 1, and I'm summarising paragraph 7 here. Proposition 1 is that had VITOL made an external hedge, by reference to this internal price risk, the gain would reduce the loss, and it would reduce the loss in a way that is not res inter alios acta, that's just an aside, an embellishment of 7, because that was the position in cases like Choil and the previous Glencore case. So proposition
just hang on
1...
1 second. If VITOL had made an external hedge, this would be a case of avoided loss. Is that what you?
Yes, well, reduced loss.
Yes, thank you.
Proposition 2 is...
Sorry,
I think the judge said it would be mitigated loss, but you would rather
mitigated.
You prefer the analysis of avoided loss. But
Well,
it doesn't matter.
I don't think it does matter, because our analysis of this is that there was action taken in mitigation, albeit internal action. It was nevertheless action, and that is the point of the Transworld and cases of that nature, in terms of the internal role, and that was action in mitigation which avoided part of the loss. And so it is both mitigation and avoidance. It's mitigation by avoidance. The avoidance being, I'm coming on to my third point now, but the avoidance being the avoidance of what would otherwise have been a necessary external hedge on a book basis. So proposition 1, if external, the gain would reduce the loss, see para 7, with the gloss that it would also not be res inter alios acta, because those are the authorities. Proposition 2 is in paragraph 30. Second sentence, essentially, although one would need a bit of a run-up to it. To talk about hedging, and the submission there is that there is no substantive difference between an external and internal hedge, save that the former place greater financial burdens on the entity seeking to hedge, and that's what I might briefly summarize as transaction costs.
I'm so sorry. Could you just give the proposition again?
Yes, there is no substantive difference between an external and an internal hedge. And that is the submission in the second sentence of paragraph 30, save for what I can describe as transaction costs. So if you go outside, you pay transaction costs. If you go inside, you don't, or they're less, or they're swallowed up by overheads.
Just one moment. I promise not to be this slow throughout, but I just wanted to pop back to you said that your first proposition could be found in paragraph 7.
Yes.
Yes, I see. Yep. Okay, I'm with you. Now, your third proposition.
My third proposition is that where the hedge is internal and not external, VITOL makes a gain which goes to reduce the loss, consisting of the avoidance of the external hedge which would otherwise be necessary.
Would you repeat that? Where the hedge is internal,
Where-
VITOL makes a gain which reduces the loss.
In that it avoids the external hedge in the opposite direction that would otherwise be necessary. Now, I added in the opposite direction to my script, because that's how the gain was made here.
And you say that proposition 2 is to be found in your original study.
In paragraph 22. So the skeleton says, the learned deputy judge found and made a finding that the most likely position as to what might have happened to the risk transferred into ID 103A was that there was a sufficient number of countervailing positions within VITOL that there would be no need for the risk management desk to take a decision about external hedging or speculating. And this is what I rely on. And it would follow that if the market movement referable to the delay in noding had not been offset. Now, offset, my lady, is a reference to judgment paragraph 144. The offsetting was the rolling of the swap and the acceptance by the other side of the roll. Had not been offset, so he's considering the counterfactual, no offset, and as we see from the judgment, no breach, no offset, within the Vista hedge, then the corresponding risk would, emphasis, have needed to be hedged externally. And in short, my lord, that is our appeal as to why the judge was wrong. And he did not carry through the inevitable consequence of that second half of paragraph 22 to say that the external hedge was avoided and that is a gain. And really...
and was he asked to?
Not exactly in those terms, no. And that is why we accept that the argument was not put in exactly this way below. But the point is in the skeleton. The original skeleton for the appeal is so far as I'm going at the moment, rather than the judge being asked to do things in a particular way. And I will come to that, and as part of both my submissions about why the point is good and also why we should be allowed to run it, my submission on that will be that nothing could have gone differently at trial had it been so explicitly argued, for example, in closing. Now, our supplementary skeleton is...
So just before we leave your three basic propositions,
Yes.
do you have to establish each?
That is a very good question. I think I have to establish certainly the third.
Yes.
And
And the first may not be controversial.
the first is not controversial, and I don't think I do have to establish the second.
You don't have to establish the second.
No,
No, I was just wondering how that fitted in.
no. It's really...
It seemed rather a bold proposition as a naked proposition.
Yes. It's really a ground for supporting the third proposition. Now, as my Lord Popplewell says this is a bold proposition, can I show you the evidence of Mr. Smith, the VITOL's witness, on that particular point, and that is in the supplementary bundle, tab 19, which was day 1 of the file, at page 220 in the bundle. And it might be convenient to read a little bit more of this than goes directly to the point I'm now making, because this page deals with points, the page of the transcript deals with points that I'm going to make. So, can I...
So are you at page 220?
Of the bundle in tab 19.
Yes. Yeah.
And by way of orienteering, it was day 1 of the trial, and it was cross-examination by Mr. Young of Mr. Smith. And at page 137 in the top left quadrant, Mr. Young had been showing the witness the public statements by VITOL saying, in effect, that they hedged wherever possible and they were conservative. And so at 138, he summarizes what he'd just been reading out at some length in line 4. So what VITOL SA, the managing director of VITOL SA, was saying in May 2008 is that VITOL is not in the position of speculation and that it uses sophisticated hedging to manage market risk. Was there any subsequent public statement by VITOL changing the strategy from that which is described in May 2008? Witnesses, I don't know. And then he asks a question about what a ship owner would think. And then over the page, which I don't rely on, and then over the page at line 4, 139, yes, well, this is a letter that has been written by the then managing director of VITOL describing the principles by reference to which VITOL operates. Do you have any reason to suppose that those principles changed between 08 and 20? I think it's probably a lot more complex than explained in that article or response to the article. So complexity would be in the sophistication of the hedging that was engaged to manage market risk. Would that be right? Correct. So VITOL has a principle of sophisticated hedging of the market risk, but the sophistication of that process has been developing between 2008 and 2020. I would say our business has, yes, become a lot more sophisticated. Although that is point one, which is down the line in my submissions, but which is that they had a policy of hedging, now more sophisticated, and the policy that was read out was hedge wherever possible and do not speculate. As I say, that fits in later on, but rather than come back to it. Now, so far as the difference between internal and external goes, it then starts at page 139 of the original line 21. Yes, said the questioner, so far as hedging, whether sophisticated or not, to manage market risk is concerned, the purpose is so that VITOL SA's profit and loss across VITOL SA is the same, whether the hedging is internal or external, apart from the costs of going external. Would you agree? Yes, yes. You're very helpful to describe how a decision is made, whether to speculate in the event that there is an imbalance that is thrown up, or you can hedge externally. Would it be fair to say that it is entirely serendipitous whether VITOL hedge internally or externally? We, from a commercial analyst point of view, we do not consider whether it's internal or external. It's all the same to you in terms of risk management, yes. And that is why I support proposition 2, albeit not necessary.
Well, he comes back to the answer.
He does in re-examination by the judge on the second day,
Yes.
which is
It's convenient to look at that.
it is, which is
Take whatever course you
yeah,
like.
239, my lord. It starts really at 238 in line. Sorry. Yeah, page 15, line 23, and 139 is two out because that was the draft transcript, and then he quotes that.
Just one moment, sorry. So we're bundle page 238.
Yes, tab 20.
Yeah, so
Just across the
internal page 15.
bottom of internal 15, the judge
Quotes
identifies what you've just been
quotes
showing
that
us.
answer just so, my lord.
Yeah.
And he said, well, he quoted that from a commercial analyst point of view. And then the question the judge asked is at line 9 of page 16. Just help me with what you meant by from a commercial analyst point of view, as to what you were trying to get across there. The commercial analyst is responsible daily for reporting the P&L, profit and loss, across a whole bunch of different activities. So when we are looking at this specific Vista hedge, the Dijilah 1037645, it doesn't impact whether those hedges are internal or external. When we are analysing the P&L specific to the Vista hedge, it doesn't impact on whether it's internal or external because the maths of the profit calculation would be the same. All right, so that is saying that from the point of view of the Dijilah hedge, correct. I see, yes. And so just the previous point, you said, I think, that the VITOL SA profit and loss is the same whether the hedging is internal or external. Can you just explain that to me? Because an external hedge includes a transaction with a third party, whereas an internal hedge doesn't. So at the moment, I'm struggling to marry those up, and that may just be a basic misunderstanding of on my part or not. And then the witness reread the transcript. I think, my lord, in that question, I'm still referring specifically to the Dijilah Vista hedge that we are talking about, whether or not it's VITOL's P&L. But this Vista hedge is the same, whether it's internal or internal. This Vista hedge that we are discussing on page 32 and 33 would be the same. And we'll go and look at those are blown up ones that your lordship asked for. And the judge said, right, okay, I'm not sure that's quite the answer you gave Mr. Young, but I'm not trying to get you to change or confirm your answers before, but your explanation is that whether hedging is internal or external, the profit and loss to the particular Vista hedge is the same, correct? That is what I'm saying.
The particular Vista hedge, in the judge's words, means
the internal between 103.
Well, it means the 645 portfolio.
It means the transaction between the 645 portfolio and the 1037 portfolio. I think. Oh, maybe this may mean the Vista match.
Yes.
Yeah.
That seems obviously right to me. That's the double book entry.
But
it does make a difference if you look solely at the one side of the book entry, 645.
Yeah.
It doesn't, as he goes on to say, if you look at VITOL SA.
But and then he goes on to say, yes. And how would it affect VITOL SA's profit and loss if a hedge was internal or external? If the hedge was internal, it would have zero impact because the hedge would be positive somewhere and negative somewhere else within Vista. If it was external, there would be positive and negative cash flow. But my lord, what he said originally, as pointed out by the judge himself, was VITOL. It's the same to VITOL. Well, that's how the judge analysed it at back to 220, page 139. And the question was very specific. Lord, so far as hedging is concerned, whether sophisticated or not, to manage market risk is concerned, the purpose is so that VITOL SA's profit and loss, and then the words across VITOL SA, is the same whether the hedging is internal and external apart from the cost. Would you agree? Yes, yes. And my lord, if that is true and correct, on the hypothesis that an internal hedge saves the need for an external hedge.
But that wasn't being explored at that stage.
It wasn't.
And that wouldn't be the case if, for example, the risk, assuming it was still identified the same risk, was being run speculatively.
Yes, my lord, but...
There was a general proposition that it isn't right.
Well, my lord, it is right if you add...
right if you're right on your third point. That
yes.
But it's not right as a general proposition.
But it is only right in the sworn evidence of the witness. If I am right on my third proposition, I'll turn that round, my lord. It's not that this is right if I am right. It is that this can only be right if I'm right. And that's what the witness must have had in mind when he says it's across VITOL. Across VITOL is very explicit in the question. And my lord, so that is why I say...
Well, no, it wasn't what he had in mind because he clarifies his answer later. But anyway, you say you can rely on what he said first time.
Yes, well, he clarified his answer, but his answer was that...
And these aren't his words, these are the words of the question. But
yes.
I understand. You rely on that passage.
His answer in re-examination was that, yes, well, the internal hedge, and I suppose I would add the words of itself, doesn't affect the profit and loss of VITOL SA across VITOL SA. And then he said an external hedge would. But he was looking at it just from the point of view, as your lordship has pointed out, of the Vista hedge, which is the double entry bookkeeping. So, whereas on the previous day at 2:20, in the bit that I rely on, he was being asked a much more general question, following on from a line of questioning about VITOL SA's policy as a whole. And either subconsciously or consciously, he must have given that answer on the basis that it doesn't make a difference if it's internal or external, because the internal will save an external. I put it this way, it's not explicit, it wasn't explicitly put that way, but it is the only basis on which that answer can be right. And it was a very clear question, it was yes, yes. And in the re-examination the next day, he was thinking more about the position from the Vista hedge itself and from the Giordano trader itself. And in this context, because it will come back, I might remind your lordship that Mr. Smith was a commercial risk analyst. He wasn't the trader. He was in the risk analysis department, as it were, but he wasn't sufficiently senior to make decisions about speculating or external hedging. And this comes back on the question of whether I should be allowed to run the point in this particular way if otherwise I'm not. Because this is the witness they chose to call at trial on the basis of the pleadings as they then were, which I will submit later, covered this way of putting it. And he
Pleadings would have covered almost anything.
Yes. Yes.
The pleadings were
beautifully wide.
You've got to take into account any loss which is avoided by hedging.
Yes.
And that's the only pleading I found.
Yes, that's the only pleading there was. That was the pleading on which the trial was fought, I am told.
Yeah, the issues would have been narrowed by the way it was opened. Sure.
Long after, yes, by the way it was opened. Long after decisions as to witnesses have been taken. And so narrowing it by the way it was opened, had no impact on the witnesses that were called. I suppose in theory there could have been an application for a late witness if any relevant evidence were thought to be possible, which is another point I'll come to. But the point is that they call the witness and they call the expert on a pleading which encompassed the point I wish to make. And they call the risk analyst. And
but just to be clear, Mr. Smith was a risk analyst, but not somebody who was sufficiently senior to consider whether to take an external
or
position.
As opposed to speculate. And the evidence, and I think it's common ground, was that there were only three options. Match it internally. If you can't match it internally, then you have to decide you have to make a positive decision to speculate, or you follow the policy of external hedge. I would put it as high as this, although not any witness or judge did. The default position would be external hedge because of the policy, but I'm on in my submissions. My Lord, the third point, so that's the difference between internal and external. The third point is to be derived from page 220, is that the seniority point that my lady has just adverted to, and that comes in at the bottom at 140. So after, from the commercial analyst point of view, and then he says, the cross-examiner was talking over him, and then he says, that's okay, for the risk management of those physical cargoes we use internal hedges. Then there's a serendipitous question. We would not tend to use external hedges for these physical cargoes. No, unless the internal system didn't generate an adequate hedge. Then you would have gone externally. So the question was put to the witness. Then it's not the commercial analyst's decision to hedge externally. And he's a commercial analyst. No, that would be a decision of somebody senior in VITOL, making a very positive decision about how to trade correct.
Trade.
Yes, but in context, my submission is that trade includes taking an external hedge. Because if you look at the page before, the answer is, then it's not the commercial analyst's decision to hedge externally. And then the next question was, no, that would be a decision of somebody senior in VITOL making a very positive decision about how to trade. Correct. So trade there clearly in context means hedge externally or not.
Perhaps a more attractive way of putting it from your point of view is whether to trade on a speculative basis or on a conservative basis. It's about the philosophy of trading in that situation.
It's above Mr. Smith's pay grade, if I can put it slightly brutally in that way. So it really doesn't matter whether it's trade or not, but they're talking about the decision to externally hedge or not. And so he was asked the question, and he said, I'm too junior.
Could you hedge book risk?
Yes.
By deciding to physically trade as opposed to take out a derivative?
In theory, I don't see why not. So trade there could include buying a physical opposite risk. But I think in context of talking about external hedging, that would usually be taken to mean something done by a higher up who is not a trader. I don't think for my purposes it doesn't really matter, because if the external hedge had been a physical rather than a derivative one, the result is exactly the same. So my third proposition was that it was argued, it was contained in the ground of appeal, and it was put to the witness at trial, the only witness they called, and the nearest witness who could say anything about it. My third proposition which is that that there would be an external hedge otherwise, and it was also put to the witness, the second proposition, that it made no difference whether it was internal or external, and I accept that subject to the answer the next day, but at least in terms of being put, those two essential building blocks were put. No difference between internal and external, and you would have hedged without the internal. So, and that is material to whether I should be allowed to run the point. So, to develop, in effect, the third point, as I submitted before, our supplementary skeleton is really a long-winded way of making good that point in paragraph 22. And the steps are these, if I can summarize them and then go to the supplementary skeleton, taking in both the question of whether I can fairly argue it and whether it's right or not. The first step is that it was the VITOL policy to hedge directional price risk where possible.
Sorry, again. First step.
It was the VITOL policy to hedge directional price risk where possible. Yep. Lord, we've got the references to the documents and the evidence of that in this supplementary skeleton, and in the first segment of the cross-examination that I read to you just a moment ago was Mr. Young putting that to the witness, and the witness essentially agreed with it. Or he said, the documents from 2008, that was the document that said hedge where possible, and the witness's evidence was, in effect, I summarise, yes, it's still that now, but the hedging is more sophisticated. And I would make the second proposition, which is that the relevant hedge here was not the original Vista hedge, the double entry bookkeeping. It was not the next stage of affairs, which was the Vista hedge between different portfolios, because those all took place long before the breach, when the contract was made. The relevant hedge in a mitigation avoided loss case is the rolling of the hedge, because that is the only thing that was a consequence of the breach. And my submission is going to be that although the judge had this point firmly in mind at points in his judgment, my submission, his decision, particularly on res inter alios acta, he lost sight of that fundamental point, because he went on to say that the original transactions, which underlay the original Vista match and the original Vista hedge, the interdepartmental hedge, predate the breach and therefore could not have been caused by the breach and therefore were not res inter alios acta. That's paragraph 180 of the judgment. That's a point down the line. So it's fundamental, and my submission explains where the judge went wrong, to always, and not just sometimes, bear in mind that it's the rolling that counts. And, my lord, the rolling was dealt with by Mr. Smith at paragraphs 37 to 40 of his witness statement in terms that were not challenged at pages 10 to 11 of the supplementary bundle. Under the heading, the consequences of the delayed loading at Dijilah, and therefore, this, in legal terms, this is the consequences of the breach.
So sorry, I'm slowing getting the reference.
This is supplementary tab 1, page 10, paragraph 37 and following of Mr. Smith's only statement in the witness statement. And it's interesting that in paragraph 36 he says it also had consequences within Vista, and then on 4th of May, because of the delays to the vessel and consequently expected changes to the pricing under the Total contract, that's the relevant one, the buy-in, a commercial analyst at VITOL SA rolled the internal hedge for 7 May to 15 May. Now I should pause there, I'm going a bit too fast. The original swaps were, the price was based on a 5-day spread of days following the bill of lading on the relevant index. And so, in effect, the hedge is split into 5, I suppose, mini hedges or segregated parts of the hedge. And so they rolled them one by one as they became useless, I think he calls it. So the commercial analyst at VITOL SA rolled the internal hedge for 7 May to 15 May, as seen by the second line with the trade type SWP, which I infer means swap, in the Vista screenshot on page 19. That is page 32 of the supplementary bundle. And he then explains what was done. The internal hedge was rolled to 15 May because VITOL still held paper hedges for 13 and 14 May, which at this stage remained useful to the trade. The rolling was moving the earliest date of the hedge, 7 May, to the first trading day after the previous hedged positions ended. So they're taking the first day and adding it on to the end, if you like. They're taking day 1 and making it day 6. And then later on, they take day 2 and make it day 7. That's 39. On 5th of May, VITOL rolled the internal hedge from 11 to 18, as seen by the third line with the trade SWP on the screenshot, and then 40, and then on 12th of May, VITOL rolled the 12th to 19th. And there's a weekend in the middle, which explains why there's only 3 hedges rather than 5. And if you turn to page 32, if I may, perhaps we should start at 31, but 32 is the one, and hopefully there are now larger and more legible versions.
So sorry again, I'm just being slow. Where are we going next?
The document is at bundles, supplementary bundle, tab 2, pages 31 to 32, and that is hard to read, so I hope we have offered bigger ones. And
I think you were. They will have been sent by email, but I haven't printed them.
31 and 32. And then 31 and 32 again. Oops, I've torn
I
some.
have them, thank you.
My lady has
There's a 33 on the end, sorry, there's a 33 on the end, I beg your pardon.
my lady has all of them. So it's just. So does my lord. It's only me.
What of my notes are on the small version, so this is going to be challenging. So, just to explain, although this is at an earlier stage, at page 31, this is the Vista printout showing the original purchase and the hedging done for that. No, the original transaction, both sides, purchase and sale, and the hedging done for that, I beg your pardon. And if you look at the second line, there is the physical. If you look at the far left column, it says trade type, top of page 31, where the text starts. And then there's fifth, which is physical, and there's fut, which is future. So the first 2 lines relate to a physical deal, and this is the purchase from Totsa of the Dijilah cargo. And there are 2 lines because there was a shortage on turnout, the 684 barrels, so you can ignore that. It's essentially the second line, which shows a physical purchase of 920, and then over to the right, in that second line, on the sell, that's the buy position. So on the sell position, you have August and you have VAS, which is VITOL Asia. So the second line represents the risk in the VITOL Vista system in respect of this parcel, both on the buy position and the sell position, identifying the buy position is from Totsa and the sell position is from VITOL Asia. And then, as I understand Mr. Smith's evidence, at paragraph 28, this is, all of the futures down to the one that says 171 barrels, so all but the last 3 futures transactions are the internal swaps, not the internal Vista match, as it claimed to be called, because that is the buy position matching with the sell position horizontally. But all but the last 3 future transactions, Mr. Smith explains, are internal hedges done with other aspects of
I thought those were essentially hedges by way of futures.
Yes.
Not swaps. Futures on the IP.
No. My lord, that's true.
To hedge the price movement in relation to receipt of the sale proceeds from VITOL SA. They weren't in any sense hedging the floating price risk in relation to the purchase.
My lord, I think that's true. If your lordship looks at the counterparty in the sell position, sorry, buy position, and the counterparty in the sell position, the counterparty, except for 4 Mizuno transfers, so I should have said that the second foot in the fourth row is a Mizuno future, misfoot.
Yes.
And the last 3 of futures transactions are misfoot.
Yeah,
Sorry, I mean, so
and we've got the complication of some external hedging being applied.
Yeah.
This is all on the sales side. This isn't hedging.
No, this is on the whole transaction, because it's, the buy and the sell have been matched in the second line. Buy from Totsa, counterparty Totsa.
Right.
Counterparty on the other side is VAS, which is
I
VITOL
understand
SA.
that. They only create this portfolio 645 when they've done the Vista match between the physicals.
Yes.
But where do we see this is produced? We think, I assume, at 5th or 6th of May, which is the date we've got in at the top. Where do we see the original swap?
There's nothing other than this entry, and the original swap is everything other than the misfoot futures, because if your lordship looks under the buy position, counterparty, other than misfoot at the top, it's VIT-int, which is VITOL internal. And then if you look at the counterparty over under the sell position...
I'm sorry, everyone else I'm sure knows this. I get it int, obviously. What is misfoot?
Sorry?
What is misfoot?
Mizuno...
Mizuno. Well,
Mizuno
what is
bank future, which is an external hedge.
precisely?
But in fact, against lower loss on the sale side, not the purchase side. And then if your lordship looks at the counterparty, then on the sell position, the counterparty is always, including the Mizuno ones, 1037031, which is the other portfolio. It's our portfolio. Sorry. It is the Dijilah portfolio. I think I'd better go.
It's not always that. You look at the 185,000 barrels. That does have a counterparty 1038101, which is the portfolio into which the swaps and the roll of the swaps. The one that ends 031 is a different portfolio.
Possibly. So our portfolio is 1037645.
And just to follow through, I did a quick tot up of all the numbers which were at the FUT futures at the left-hand side, and I think one needs all of them to get to 920,000 barrels. And these are, we see in the form of the product, IP Brent futures, which are long-dated futures, not dated Brent under Platts. So it looked to me as though maybe we haven't got the whole screenshot for the relevant date, but as at the 5th of May, we haven't got recorded here the original swap, which one imagines must have been taken out
Originally.
Have we?
My lord,
Mrs. Thompson.
I've lost.
That's as far as I could really get in trying to understand it.
My lord, I'm loath to interrupt my learned friend, but just if it assists so that we don't proceed on a false basis, your analysis is correct, my lord. We can see that from paragraph 28 of Mr. Smith's statement, where he explains the futures concerning the VITOL Asia transaction in the way that you've just described, my lord. That's paragraph 28. And when it comes to the swaps with which we're concerned, we'll find those on the following page, page 32.
Yes.
Which is at a later date, once we've got more.
I've probably misinterpreted the earlier document. If my learned friend very helpfully refers to page 8 of the supplementary bundle, Mr. Smith's statement, and I won't read it out, but it's from 25 to 29, he explains those transactions, and then he says there were internal hedges, but your lordship is right that they weren't internal hedges with the same counterparty. My lord, my submission is, though I misinterpreted that, the essential point is on the next page,
Yeah.
which is 32, which is the rolling. And that has the same format, trade type, period, counterparty, product, and both for the sell side and the buy side. And this is looked at from the point of view of the portfolio ID 1037645, which is the JNO one, the JNO one.
I've been calling them 645 and 101. If
that's much better.
that easier?
645 and 1. This is from the point of view of 645, and ignoring the FXF, which are foreign exchange futures, one comes to swap SWP down the left-hand side, and that is a swap. And there are 5. Firstly, there's the a swap transaction for the full 921 barrels in the first line, and that is between 101 and 645 in my submission. And then Mr. Smith explains...
That was the original swap before the delay.
Yes. And then Mr. Smith explains that the next 3 are the post-delay, post-breach swaps, which are also described as rollovers. And if you look over to the right, far right, under the column, say, FVPNL, which I think Mr. Smith explains means the VITOL P&L, the F might be final. Your lordship will see the figures running from 182 to...
slow, I can't, where do I find that?
Where the green line is.
Just
Oh, I
next
see,
to the
yes.
green line.
Yeah, that's the green line. And black is again to the relevant portfolio, 645. And you have the figures from 18, then -5, 12, 305, and 1026. And the next figure, on my very, very shaky arithmetic, come to the almost 2.9 million gain that was booked to portfolio 645. Now,
Just so we understand what these transactions are, because I'm going to want to explore in a while exactly what you say the oppositional netting off transaction is, and what you say the instrument was that was the avoided booking. But these are, forget whether they're internal or external. If these were external, this is essentially, on each date, a fixed price being paid by 645 for a swap in return for a floating price payable by 101,
exactly.
by reference to that quantity, a fifth of the cargo, on that particular published date of Brent. On the
Exactly. So it's a new...
And the fixed price will depend on exactly the date on which the swap was purchased.
Yes.
So you've got different prices because they're for different days as well as for different published days.
Yes. And Lord, 2 points as follow. Sorry.
Go on. And so the equivalent transaction in 101, which is the sale of this swap, is 101 is paying these fixed prices in return for an obligation on the various published dates to pay whatever dated Brent is on those published dates.
Yes.
And that's the risk that goes into 101, which we then will need to keep our eye on to see what happens to it.
Well, that is 101. That is 101. Buying a hedge, or what? Transacting a hedge. If it was external, contracting a hedge with 645.
Depends whether you talk about the buyer being the fixed price
Yes.
buyer or the floating price buyer, but it's selling a hedge in that it's selling an agreement to pay a floating rate. It's a floating rate seller in return and a fixed rate buyer.
Yes. And And the 2 points that I invite you to conclude from this is that, firstly, this is a separate and mitigating transaction, even if it's not a contract. If it were a contract, it would be an actual contract on those terms.
Say it again. This is
a mitigating transaction in response to the breach. From the point of view of 645, which would be a contract if external.
Yeah, that's your proposition one.
And proposition 2 is that, looked at from the point of view of 101, they have contracted a hedge with 645 for the purpose of hedging, by the means that Lord Justice Popplewell described, the risk of a fall in the price between the day of contract and the closing date of the hedge.
Well, I'm not sure what that follows. I think Mr. Smith's evidence was that nothing that the matching does, i.e. the book entry in 101 does, is intended to balance risk. The way it works is the trader on 645 is expected to hedge, takes out the original swap, rolls when there's a delay, and there is a portfolio found which has to take the opposite. But Vista doesn't at that stage look for someone who's got an exactly matching thing, and within 101, at least at that stage, there may be an accumulation of risk. Isn't that his evidence?
I'm not sure, maybe, I'm not sure exactly, but perhaps if you look at one, I think that there is this slight difference in that the rolling was a positive decision taken by an analyst. Yes, para 61, page 88 of the core bundle. So I think my lord might have meant to encompass this, but the para 61 to 64 are at the heart of this.
Which,
of the judgment.
Page 66 of the core bundle, at 8.
Yes, sir. We're against the judgment.
Sorry.
So judgment at
61 to 64.
Thank you.
But perhaps we, and this is reflected in the evidence, but perhaps we should start at 56, just to observe that at 56 the swaps were originally recorded on the 30th of March. That's the original swaps, not the Vista match. The Vista match is matching up the Dijilah, the purchase from Totsa with the sale from VITOL SA, as I understand it.
But it may have been about the same time, because that was quite shortly after.
Yes, yeah. But there's 2 stages. You match the buy with the sell of the actual physical, and then Vista automatically searches for opposite risks and enters in a hedge. And that's what I think the judge finds in paragraph 56. So down to 58. So 56 to 59 is the second stage, which I will call the original swaps. 58, the swaps were allocated to a counterparty, namely 101, no external hedging. In other words, logged within Vista. The effect of these entries was to transfer the pricing risk from 645 to 101. And
So where are you reading from?
59, my lord.
59.
The effect was to transfer the pricing risk arising from the purchase of the Totsa cargo from 645 to 101 to sit alongside the pricing risks already contained in 101 from other unrelated transactions. So there's a contract between, a transaction between 101 and 645 to that effect. Mr. Smith says that's to consolidate, and then this is, I think, where my Lord's explanation might need a few more particulars. After it became apparent that the vessel's arrival at Dijilah would be delayed by reason of the detention at the Takoradi anchorage, i.e. the breach, and therefore that the actual pricing dates under the TOTSA contract would be later than anticipated, a commercial analyst in VITOL took steps over a period of days to roll swaps already in place for the TOTSA contract, such that the pricing dates of the internal hedge matched the delayed anticipated dates for the pricing of the TOTSA contract. The effect of this was that the swaps after rolling would close at dates that were anticipated to be the dates of the quotations used to determine the purchase price in total, i.e. they would match the bill of lading pricing dates.
And that's what you've just shown us.
Yes. At page 32, not page 31.
Yes.
And then 62 over the page, he says that specifically in line with the physical sale under the TOTSA contract, and this is important, but for the delay to the loading date, the swaps would not have been rolled in this way. So a commercial analyst wearing, if it were external, he would be a broker wearing two hats. Wearing a 645 hat says, I will pay a fixed price. And wearing his 101 hat, he says, I will contract to pay a floating price. And so, although compressed within the breast or mind of one commercial analyst, analysed properly by analogy with an external, there is an offer and an acceptance for a completely new swap that just happens to be able to be called the rolling of a swap.
I think you may have misunderstood my cavil.
Oh, sorry.
Cavil was, with your suggestion, was that what 101 was deliberately doing was hedging a risk of a fall in the market for the purposes of what else was in the 101 portfolio. And that's certainly not either what the judge found or what Mr. Smith said was happening. He said, we can probably find it in the transcript, Vista doesn't match oppositional positions within the portfolio. It's not seeking a portfolio in which there is either the exact or more realistically the equivalent oppositional risk. It's just moving the risk into another portfolio where it's accumulated and it may add to the.
I accept that. But
I'm sorry, I didn't make myself.
No, I misunderstood. But it doesn't affect the point, which is that there is an opposite risk, not necessarily in that other portfolio, but somewhere within the computer of Vista.
What do you mean by opposite risk? You say there is somewhere. There must be somewhere in the computer a specific risk.
No, an accumulation of many little bits and pieces.
Right, and that accumulation, does that, by virtue of an algorithm, enable an accumulation of risks which are referable to different indices, say, Brent futures and Brent Direct and West Texas Intermediate, or whatever it may be, the various different indices? Does it do that?
Yes.
And does it also allow an accumulation and netting off of risk between different types? Those are all pricing indices risks. But Mr. Smith says sometimes these portfolios will have thousands of entries. We've seen some of them have got foreign exchange risks, some of them have got futures risks. I imagine there'll be freight derivatives. I haven't seen any on this. Does the algorithm allow a net analysis, as it were, of risk, putting all those together so that at the book level you've got a risk which is not necessarily directed just to Brent Direct, indeed, and certainly won't be directed to Brent Direct on those particular dates, and certainly won't be directed to a hedge which is a purchase of Brent Direct on those dates, where the purchase price, the fixed price, will depend on exactly when you're doing it. And the reason I'm taking this rather long run-up is I'm quite interested to know what you say this avoided book hedge looked like.
It looked like exactly the contract that 645 made with 101, as represented by page 32, is my submission.
So at some stage, I'll come back to at some stage, if there weren't something else in the system, VITOL would have gone to an external hedge and bought 5 swaps on those different dates on which the swaps were rolled, specifically by reference to the Brent direct price on the 11th to 19th of March, I've got the date wrong, 13th to 19th of March indices. Is that your case?
Yes.
What's
Because the evidence is that what the VITOL system did at the time of this rolling is to identify the opposite risk to the risk created by the 7-day delay under the TOTSA contract. The risk created by the 7-day delay under the TOTSA contract was a rise in the market between the day the bill of lading should have been issued and should not have been issued.
a rise in the market expressed by reference to Brent direct? Rise in the market may be expressed differently on different indices. I don't know. West Texas Intermediate may lag behind. It may be different.
Fair enough.
The arbitrage, the differential between Brent futures and Brent direct, that'll all have to be dealt with in an algorithm, which will be subjective. It'll automatically make a whole series of judgments as to how let's say that freight derivatives are involved, as to how freight derivatives relate to particular pricing markets and so on.
Yes.
So what is this avoided book hedge?
The avoided book.
It won't be by reference to Brent direct on those dates.
We submit it probably would.
When would it have been taken out?
On the same
on
day.
those days in May. So they would have gone to an external hedge on each of those days and bought for a fifth of the volume exactly those swaps on their book.
Yes. As being the best way to replicate what they did for 101, as represented by page 32.
Even if they at that stage, what they see in their book doesn't identify Brent direct on those dates as a risk. It's got an overall pooled risk.
But it has an overall book risk, which is taken away. This is the evidence. There is Vista on the days in question, and it happens minute by minute, I suppose, but day by day certainly. Vista on the days in question identifies 4101 or 101 on the basis of many other transactions. And what is found in the judgment as an opposite risk. And I can't tell you, and perhaps nobody can tell you how it does that.
But that wasn't the evidence. That's not the finding, and it's not the evidence. The evidence of Mr. Smith is it doesn't look for an opposite risk.
It looks for
it can accumulate risk.
Yes, it looks for an accumulation of risks that creates an opposite exposure.
Well, at a much higher level, they are all pooled, as Ms. Bosley put it graphically, but these metaphors are sometimes obscure rather than illuminate.
Yes.
It's all these risks in individual pots are mixed up within the individual pots, they're mixed up in other pots, they're put into the whole book.
Yes.
But once they've got into the whole book, they're not expressed in the same way, are they? If the algorithm does what you're describing, they're not the same. They're not identified. There won't be in the pot which represents the book anything which you can look at which says that is this risk.
Quite.
The algorithm may have said if the price rises on West Texas Intermediate, we're exposed because it's done some algorithm with that. It might say, well, actually, our main exposure is to freight derivatives, and we must take out a freight derivative hedge because we've done an algorithm which puts a correlation between prices and freights.
Well, we're dealing with the prices of oil, so I don't think, unless the CIF, but that was in the contract with VITOL Asia. So I think We're concerned not with freight derivatives or currency or anything like that. We're concerned with the price of oil.
Well, VITOL is chartering vessels.
Yes.
It may or may not choose to hedge
It probably does.
the risks, but it wouldn't surprise me if it did. And then they would go into this pool.
No, it wouldn't.
And there may be an algorithm may do something with those. And of course, I'm speculating.
Yeah.
But all of this is necessary, isn't it?
No.
If you are going to say the instrument, which was the avoided hedge, would have been identical to the individual rolled swaps.
I can't say identical, and it would have certainly had transaction costs.
Well, leave aside transaction costs, but in terms of the shape of the instrument.
The shape of the instrument would have been designed to do the same thing as the rolling of the swaps, and therefore would have been as close as possible to it. I think that's as high as I can put it. But I do that in two stages, my lord. I say, firstly, if one took out the 7-day delay to the Totsa cargo and that risk from Vista, that would have left the combination of risks thrown up by the computer unmatched. Now, that wouldn't be identified on an individual risk or an individual instrument basis, but Vista would have thrown up the result that we are exposed to the opposite risk of a fall in the price of oil, I submit, over those 7 days. And that was the internal risk looked at from the point of view of 101. Absent 101's side of that deal, the internal roll, something would have had to be done. And that was the evidence. And that was the finding. And the precise mechanics of it, we will never discover, and I can't assist your lordship. But the intent, what would have been done is risk management by some form of hedging. It would have been external, and it would have been designed to achieve the same result. And then we come to quantum. What would have been avoided was a losing hedge, and my submission is that the best estimate of the quantum of that is, although it wouldn't have been identical necessarily, is the profit and loss on the internal hedge. And in my submission, that's a generous estimate because what was avoided was not just the pricing risk on the internal hedge and the external hedge, but also the transaction costs. So what VITOL saved by not going into this external hedge was the actual in the money or out of the money element of it, and the transaction costs, and therefore to take the internal result as a proxy for the avoided external result is generous to VITOL in my submission.
Well, indeed, why is it not a part of your submission logically that the saved external costs should be part of your quantum?
Because, my lord, I accept that there's some element of, I say probably the profit would have been 2.9 because that's what was calculated. But I don't claim the transaction costs for two reasons. Firstly, because I can't prove them. There's no evidence of them.
Well, that in itself isn't an estimate could be made on the basis of evidence.
Could have done, but I haven't.
No, but I'm not trying to make you increase your your
rebate.
Quotes. Yes, exactly.
A rebate.
I'm just trying to understand the logic of your position.
Yeah. The logic of our position is that yes, in an ideal world, we would have calculated the likeliest external hedge that was avoided, plus the transaction costs, and said that that was a saving that has to come off the 3.6 million. I'm not in a position to do that, so I make the point that that by not doing that, we are being favourable to VITOL in that they saved more than the headline figure of 2.9.
Well, but
But that gives you logic.
But that's just a sort of debating point that goes nowhere.
Well, it
It
goes
doesn't matter
here.
whether you're all you're saying is you've underclaimed.
No. We have allowed some leeway in case your lordship thinks that the figure of 2.9 million, 2.88, whatever it is too precise.
Okay, but it's an illogical leeway. You're matching apples. You're giving a.
Yes.
You're not claiming any pairs
Yes.
because the apples might have been a slightly different weight.
Quite.
And anyway, the variation in the apples might have been both ways.
No.
I missed something there.
Because what they saved by not going out externally was transaction costs that they didn't have by doing it internally.
Yes, but you were saying, and I could easily have got this wrong, so don't treat it with more respect than it deserves. You were saying that a reason why it is not, there's an element of justification in not claiming for the transaction costs, is that the 2.9 is only a best estimate, but it might be an underestimate or an overestimate, is what I'm putting to you.
True. But either way,
So again, it's illogical for you not to claim the transaction costs.
believe me, my lord, if the figures had been there, I think we would have done.
I know, I'm repeating myself. Not doing this to say you've underclaimed. I'm doing it just to understand the logic of your position.
I'm saying that if you're worried about giving us one apple too many, don't worry because we've given them two
I see.
oranges
Well,
already.
I don't think we'd approach it in that way. But anyway, thank you. I've got my answer.
But in simple terms, it is to say that when coming to, if I'm right on everything else, then when coming to estimate the loss that was avoided, this gives a little leeway so that you can be comfortable that you're not over compensating my client and undercompensating them because of the leeway in oranges, which would compensate for the overpayment in apples.
This is a whole new element.
Blueberries. So my lord, can I?
Please, may I just return, though,
Yes.
very, very briefly, because I know you want to go on, to this issue of what the hedge would have looked like. You say it would have looked like what is depicted on page 32, because you have in the opposite column there dated Brent, etc.
Yeah.
But earlier you said, and so this is picking up on what my Lord Justice Popplewell was saying, earlier you said that the Vista system would take bits from all over the place, and therefore the bucket, if you like, would be full of all sorts. So why, rather than an all sorts bucket, which might have all sorts of currency trading in it and one thing or another, do we just look at page 32?
Because
I'm sorry, I'm sure you've said so before,
No,
but I
no.
just want to be certain.
I think that gives me an opportunity because when Vista has done its work, it identifies a risk that VITOL needs to hedge. And the way they chose to hedge that risk was by attributing to 101 that hedge.
Okay.
And if they hadn't done that, they would have had to deal some other how with that risk. And that was the clear evidence, and I'm reflected in the findings, which hopefully I can show you now by referring to the long-winded document, the supplementary skeleton.
Sorry, that sounds like a different argument to me. This is so it's not an avoided book hedge.
Yes.
It's an avoided direct hedge by portfolio 645. Is it?
No.
Sorry, I thought you said a moment ago if they hadn't done the internal hedge to 101, they would have had to do an external hedge.
On a book basis, though. Because this is a decision made by the commercial analyst for the benefit of the whole of VITOL. He says, taking one thing with another for the purpose of the whole of VITOL, on the one hand, I've got 645 of this problem. On the other hand, I've got a whole bundle of opposite risks thrown up by the Vista computer. So the commercial analyst, who's a human, says, what do I do? And we are told by Mr. Smith what he does is he decides to enter into the swaps, SWPs, at page 32. Now, what must have been put into that decision is that the computer throws up these opposite risks derived from a whole range of bits and pieces, on the one hand. The computer has said that is a price directional risk for VITOL as a whole, which needs to be hedged. The computer analyst then looks at Vista and says, is there anything else in Vista that I can hedge this VITOL-wide directional price risk, which in effect is a fall in the market price of oil? No doubt the algorithm would deal with whether Brent is a better proxy or something else is a better proxy, but they use Brent.
But 101 isn't chosen on that basis. The evidence is not that 101 is chosen because it has an oppositional.
No, it doesn't. 101 was chosen because it was the party that was chosen to do the original swap. But when Vista, the computer, says across VITOL as a whole, there is this, what I will call an opposite risk, because that's the wording in the judgment. That needs to be hedged, says some commercial analyst. So he goes to Vista and he says, is there an internal match for this that I can hedge it against? And he pops up at the 645, the JNO risk caused by the 7 days delay. And he matches the two together and offsets them in the wording of the judgment by creating those swaps. That's looked at, let's say, my lord, let's hypothesize, because it will have happened this way much more quickly, but if one parses it, let's say that 101, let's say that VITOL as a whole has a broker. And let's say that 645 on its own has a broker. And that they're both commercial analysts or risk analysts, and they're sitting in different buildings, one in Geneva and one in London. The risk analyst for VITOL as a whole pops a finger on Vista and says, I have a risk here that is unmatched. Once Vista's taken everything into account, except 645, or possibly including 645, there is an unmatched risk here on a net aggregate across the whole of VITOL basis. What can I do with that? He then pops his finger onto Vista again, and he finds that 645, because of the breach, has that extra risk of 7 days delay, in respect of which the price might rise, in respect of which the total price will increase. So the VITOL-wide broker goes, I would like to enter a new internal swap with those people there, and the terms of the swap are that every day that passes, forgetting the weekend, every day that passes, the bottom one, the oldest swap will be rolled, will be converted into a new swap for the 7th day. For his part, the broker for 645 says, I've got, and it's not the original trader because now it's at the risk management level, I've got this risk created by the 7-day delay. What do I do with it? He looks at Vista and he says, he sees that Vista has told him that Vista as a whole has thrown up an aggregate opposite risk. So the guy in London for 645 phones the guy in Geneva for the rest of VITOL, or the guy in VITOL in Geneva for the rest of VITOL phones up the broker at 645 in London and says, let's do a deal. And that deal is done. And that deal is represented by page 32. Now, obviously it doesn't happen like that because it's one commercial analyst taking the decision for both sides of the equation.
Well, it doesn't happen like that because you're taking out the time factor. I mean, you're assuming that at every single second, you look at Vista and if they were separate people, they'd be taking a decision as to exactly what the risk was second by second in terms of deciding which portfolio to move it in. It's not only not the evidence, but it seems unreal to me.
Certainly day by day, because that is the evidence of Mr. Smith, the commercial analyst. But it could be taken We don't know, but it could be taken as a single decision that every day there will be a roll at
Well,
the
it's pretty clear, clear that that was what happened. The idea that he made a decision every day, it's pretty clear he made a decision of the kind you described, to roll, to go on rolling until they got the oil.
That's possible, but Mr. Smith's evidence is that they rolled on the 4th, they rolled on the 5th, and because of the weekend they rolled on the...
But pursuant to a decision taken at the
Yes.
start.
I think that's the burden of them. Whether that, obviously the price changes day by day, but you don't have to remake the decision or redo the deal every day. So what would happen on the day on the 4th of May, because that is when Mr. Smith says it happened. The notional broker for 645 went to the notional broker for the rest of VITOL and said, let's do this swap deal because I've got this risk and you've got the opposite risk. That's, in my submission, the best interpretation of that evidence. And so the result, what the counterfactual exercise is what would have happened if you take that out. And I do not make any submission, and I submit, I don't need to make any submission, but if I do, I'm in deep water, as to quite how Vista does this. Whether it merges Brent with West Texas Intermediate, whether it mixes up the price of oil as represented by Brent with the price of freight as represented by the FFA.
Or gas.
Or gas.
Maybe,
I mean,
that may not be
why would you hedge why would you hedge freight against the price of oil and gas? But
right.
if it does,
No, but crude against
oil and gas. If it
and
does,
all sorts of product prices.
but if they do that, my lord, that proves, as it will of itself, that they have a system that can satisfactorily to them match the price of oil with the price of gas and the price of freight. So I don't know what it is, but the existence of this Vista system proves that to VITOL's own satisfaction, they can, if they are dealing with oranges and apples, they can satisfactorily to them match it. Because that's the point of the system. And
They will always, you say the evidence establishes that they will seek to ensure that they are always matched to the nearest dollar, not
Yes.
to within 100 or 200,000 dollars,
Well,
but to the nearest dollar.
Well, they will try that. And at one stage, the witness said, you're at 800,000 out, but that was pretty good for this exercise. And I think he said, yes, you can't expect perfection. I can't remember the exact reference, but that they will try to get perfection, but they will fail because of, well, here they failed by $800,000. But the inherent purpose of the system is to take into account everything your lordship has put to me and crunch it in one big barrel and say, what is the total risk to VITOL at the end? And it will be done promptly, I suspect, because the markers move so quickly that if you don't do it promptly, you're left behind.
Can I just try out a point on you which may again be misconceived, but your thought experiment of the two brokers is artificial, not just for the all reasons we've explored, but also you're assuming one broker for the 645 transaction and another broker for the whole of VITOL. But in fact, there will be lots of people on the opposite, as it were, on the same side as 645, people for whom the risk is a falling price. It's not one against the rest. It's a huge variety of different trades, all with their own risks, some in one direction, some in the other.
And you could do
But
this.
does that not expose the artificiality of the exercise that you're saying is useful?
My lord, I glory in the artificiality of the exercise.
Well, I understand it's a thought experiment, but I'm suggesting it's not a thought experiment that provides a real analogy for what's going on.
I submit it does, because you could do this thought experiment from the point of view of every physical risk in the whole of VITOL.
You could or couldn't, you're saying?
You could.
Yes, exactly. Well,
I
that's
could
what
do-
I'm putting to you, but doesn't then that show that what we're actually dealing with is a holistic assessment of risk over the whole
Yes.
VITOL business?
Yes, it is. But
Then
insofar...
focusing on individual matching is not a representation of the reality of what's going on.
I don't necessarily disagree, but we are forced in my submission to do it in this case because we have to single out what net loss was caused to VITOL by reason of the 7-day delay on one particular physical risk, the Dijilah 645 risk. So we have to single out that one risk and look at it from the point of view of that one risk against the rest of VITOL. If there were another case about another risk somewhere else in VITOL, you would have to do it from the point of view of that one risk. So it is enforced artificiality, my lord, enforced by the fact that although it's a holistically done thing, it is implemented by entries in the VISTA system, which represent transactions, which would be contracts were they not internal. And because we are looking only at one of the thousands of risks.
And another very big picture point, suppose you thought, my goodness, we're going to lose an awful lot of money on this. Let's look at our business generally. And there's some facts there. We are employing too many people in the so-and-so department. We'll make some redundancies there. Or we're spending too much on upgrading our computers. We can put that off for another year. Why doesn't that go in the pool too?
Because that wouldn't be directly caused.
But in a sense, I'm just putting it to you, I suppose, are all these other savings really directly caused by the breach?
Yes, my lord, because they're produced by the VISTA system, the result of which was this particular internal contract. So they were matched together. The whole basket of risk over there was, in fact, by a commercial manager, a commercial analyst. They were actually matched together. That's what differentiates that risk from everything else. Somebody actually, a human, went through the process of taking the computer results and saying the way to deal with this is match all those risks over there with this one over here.
It wasn't that I thought I was just trying to isolate the essence of why it is that you say these other transactions had to be brought into the account. But okay.
And that also is an answer to the res inter aelios acta, because somebody actually went to the trouble of putting these two things together, well, that basket of things with this particular thing together, and that establishes sufficient causation for that. But I'm moving on. May I just say then, so I've made my submissions and they're in writing, and I've made my submissions, I don't want to waste time orally, on the fact that VITOL had the no speculating hedge where possible policy. And so what I need to do is to identify why I say that the functional equivalent of the new swaps consisting of rolling of the hedges on those days, probably on the 4th of May, would have been the same as the internal swap. But I suppose I better do it in two ways. Firstly, the proposition is in paragraphs 5 and 6 of the supplemental skeleton. And at 5, I rely on the finding that it, has to say VITOL, internally hedged this risk. That is to say, the risk of the price rise vis-a-vis POTSA because of a rise in the index price, the relevant index price over 7 days. That's paragraph 4. And then, if I can go back to the judgment at 61, where I think we were in the vicinity of recently. Yes. So this is what actually happened at the beginning of May. I think it was put into the books on the 4th of May. 61, after it became apparent that the vessel would be delayed by reason of the detention at the Takoradi, and therefore that the actual pricing dates under the POTSA contract would be later than anticipated. Commercial analyst in VITOL took steps over a period of days to roll the swaps that were already in place for the POTSA contract, such that the pricing of the internal hedges matched the delayed anticipated basis of pricing under the TOTSA contract, and it did it by moving 7 to 15, and then in that one off the beginning, one to add to the end way. Now look, that is a role which is a new forward contract to hedge the risk of what? It can only be a rise in the purchase price, because a fall in the purchase price over the 7 days is an uncovenanted benefit to VITOL. So the risk to VITOL is that it has to pay more under TOTSA. It buys a hedge that takes out that risk, but also takes out the unsolicited gain if the price fell. But the risk...
Just like the original swap. I mean, there's no distinction.
Yeah.
In this,
Except this one's 7 days, and the other one was based on... This one was for those 7 days, and the original swap was based on the original expression.
The philosophy is the same.
Philosophy is exactly the same.
And if the philosophy dictated that the original swap should be taken out, by way of hedge, the same philosophy would have informed the rolling.
Yes.
It's not different in that sense.
From
The
645...
commercial analyst isn't suddenly thinking, now I've got a very different animal to think about.
No, he's not.
It just follows from
The policy.
the policy of
always hedging.
hedging the pricing.
Yeah. But that's from the point of view of 645.
Yeah.
But he's also acting for 101. And 101 as a representative of the rest of VITOL. Because he is saying to 101, you should agree this rolling, which is a new swap, in effect, building on the old swap, but it is a new transaction, and externally would be a new contract, a variation, I suppose, an addendum. And what is he doing from that point of view? From there, how is he discharging his duty, not just to 645 and the trader there who's keen on his bonus, but to the rest of VITOL? He is necessarily saying that for the rest of VITOL, although I will put it in the name of 101, because it doesn't matter because it's all internal, for the rest of VITOL, we are exposed to the opposite risk, which is the risk of a fall. It's got to be. Quite how they do it doesn't matter, but that is the only rational reason for the rest of VITOL to make this agreement in the name of 101. It's not an agreement, but you know what I mean. And that is what the judge finds later on, that we'll find, or the effect of what the judge finds. At 62, the effect of the rolling will be closed, and then at the top of 62 he says, but for the delay to the loading date, the swaps would not have been rolled in this way, so that's causation. Mr. Smith said there's nothing unusual, so that's, if remoteness were relevant, that would be relevant, but so far as causation is relevant, then I rely on that. And then 64, the rolling of the swaps generated a gain within the Vista system. For 645, there would have been a corresponding loss to 101. And I want you to focus on that loss to 101. What would have happened to 101 without this roll? My submission, it would have suffered that loss on the external. I think you know that. And if we go to page 88 then, of the judgment, para 142, he's talked about the Mizuho Bank hedge in 141, but that's hedging on the risk on the sell side, so we don't need to worry about it. 142, apart from the evidence that there was no external hedge entered into specifically in relation to this transaction, there was no attempt to follow element risk with the Vista system. In respect of the pricing risk on the TOTSA contract, there may or may not have been further internal transactions, for example, by 101 by way of the hedge with yet further internal ID. However, the parties agreed that there were 3 possibilities as to how the risk, now that must mean that the risk created by, in my submission, the delay. The risk could have ended up being dealt with first. It may have been offset by 1 or more transactions within the Vista system. Second, there may have been a decision to seek an external hedge based upon the net risk ultimately remaining after internal offsetting of the risk. Or third, there could have been a decision which probably would have needed to be specially authorized to run a speculative position. And the experts said that's opening a speculative book, and they said that while some people sometimes do speculate, they don't speculate on physical risk, they use liquid futures. So in my submission, you can rule out speculation. I've made my submissions that they always hedge, and I've written and made my submissions on you can rule out speculation in writing. Mr. Young's case, and well, let's not worry about Mr. Young's case was, but as put to Bosley halfway through paragraph 143 in a cross-examination with which she agreed, was that in the absence of any positive decision to externally hedge or speculate in relation to a particular risk, the inference was that the risk was offset within the VISTA system. Thus, as Ms. Bosley also largely agreed, the most likely position as to what might have happened to the risk transferred by swaps into 101 was that there was sufficient number of countervailing positions within VITOL that there would be no need for the risk management desk to take a decision about external hedging or speculating. I accept, therefore, that the likely position is that the risk transferred into 101 by the rolling of the swaps was offset within the VISTA system by opposite risks, which had ultimately originated from other physical trades. That risk would be unlikely to be offset by a single transaction that was equal and opposite on precisely the same dates, but by a complex mix of other transactions, which may well in other respects in relation to other risks those transactions gave rise to be offsetting the further transactions that VITOL had entered into. And so, my Lord, the result of the VISTA system, however it does it, is to identify opposite risks to the risk run by 645 and to enter the internal swap to offset that risk. And that must mean not within 101, but within VITOL generally, there were opposite risks. They ascribed it to 101, but that's just purely internal. Now, what happens to those opposite risks in the counterfactual of no 7-day risk? Answer, they have to make a decision. Which decision? Well, for the reasons I've given, it's the usual policy decision of hedging. And that is the basis for our explaining why, in economic and practical terms, an internal hedge is the same as an external hedge. Now, in the skeleton, there, in the supplemental skeleton, that's the point I've just made is the one in paragraph 6. And paragraph 7 is the crucial one, and is where I was questioned by my Lord Popplewell. Does it follow, I think? It follows, conversely, as the other side of the offset, that someone of the relevant seniority decided that those opposite risks should be and were hedged by accepting the rolling as the offset. And that does follow my submission from para 144. And then I say, and this is another point, we say it doesn't matter that you can't identify one risk, because the very purpose of the beautiful VISTA system is to agglomerate risks so that they may be treated as if they were one risk. And paragraph 8, therefore, again, I was tested on this by my Lord Popplewell, but I do say the precise concatenation of circumstances that the VISTA system goes through to produce this result is not material to my case. The only thing that's material is that the VISTA system threw up these opposite risks that were hedged internally with 645. And then, so I'm still referring to 144, and in paragraph 8 I make a point which is that maintain the market position. The options are external hedge or maintain the market position, which means run a speculative position. That's clear what His Lordship meant from that. And then paragraph 9 is also at the centre of this. In context that there was no external hedge and no decision to speculate, VISTA necessarily conveyed the message that following the rolling and offsetting, VITOL's net risks were so matched that no further risk management decision was needed, i.e. whether to hedge an unmatched risk externally. And when I say unmatched risk externally, I mean unmatched net risk externally, or run a speculative position. And I do rely on the cross-examination of Ms. Bosley, which goes into make up the judge's decision at 144. And for that purpose, it's supplementary tab 20, page 252, and 253. this is important because this, as it were, fills out the judge's paragraph 144. So I'm looking for day 71.
71.
Day 71 internally, yes.
Page, no.
Did I say 252? I did.
You did, and it's right.
I got the right page. Wow. Okay. So at the top, well, maybe we should start at 69, line 15. No, line 10. Mr. Young mentioned the three possibilities. Enough countervailing position. It may just be that, part of the composite, or maybe there's nothing in there which offsets it.
So sorry, where are you reading?
I'm sorry. Internal page 69.
69.
Bundle page 252.
Yep, got it, yes.
Yeah.
Yep.
And then he says, just hold on to it for a few days until something pops up. That's speculating, was the question, and the answer was yes, that's speculation. Yes, and he's already asked about that. So would the correct inference be, by one means or another, the risk management desk has found a significant body of countervailing positions to match the transaction which is being hedged? Floating price range, yes. So at the end of it, VITOL is neutral within its entire portfolio, is neutral as to price movement, but it profits from the locked-in price that it has made on the purchase and sale of the contract. Is that right? The Dijilah trader has done an arbitrage, which has locked in a very nice profit for -4 plus 260. He's got some wriggle room. He goes to the 101. It has then gone to the 101 desk. What happens to after that, I have no idea. If it goes out to some other desk, what is that other desk doing with it? Are they keeping it? Is it offset for them? You know, are they doing something completely different? I won't know at all. I can't say. And that is a reference to the earlier swap, I suggest, that the 101 desk might have done something further. Then Mr. Young says, if at the end of the day the other elements within VITOL SA does not buy an external hedge and does not make a positive decision to speculate, then the only conclusion is that it has, by one means or another, found a sufficient number of countervailing positions. For the floating part, yes. Not for the fixed part. That could be higher, lower, whatever. The floating part is that which is sensitive to market price movements. Yes. Good, fine, thanks. We are, I think, therefore, at one. And it would be unusual, you say, for a crude trader not to hedge in the way you've described. A desk trader in a big organisation, it would be unusual for them not to hedge in the way I've described, depending on their initial delegated authority and their market price view. And we know the names of the traders and haven't heard from them. If you're sitting on a profit, why would you do it? You're greedy, who's forecasting. And then it's the question at page 71, internal line 20, that starts, that was just the run-up, as it were. The risk management desk.
No, I'm sorry, you said I'm going to now?
Internal page 71.
Yes, line 20.
Line 20.
Thank you.
After quoting part of the expert report, that's what we've been talking about. That's netting off the offsetting price and exposure. The risk management desk with its bucket or its succession of buckets has effectively netted them off against one another so that it hasn't needed to have a speculation decision and it hasn't needed to have an external hedging decision. Yes. So Miss Bosley, for the other, for the adverse party, agrees that that's what's happening. So with the role, they have avoided that decision, speculate or externally hedge. Now the external hedge, now if in the counterfactual, if you take out the Jano risk, the external hedge would have been the same, as close as we could get it, as the other side of the Jano roll. Not the original swap, but the other side of the roll. And if you turn to page 254 and internal pages 78 to 79, she was taken back to that, or she came back to it, of her own, I think. And well, perhaps we should start with the question on the last line of page 78, which is 25. If it hasn't been decided, if it has not been decided to take a speculative position, and if it has been decided not to hedge externally, the only conclusion is that the risk management desk has found enough internal transactions which are of equal and opposite effect to create an offset. Possibly, but if the Dijilah transaction had not happened and the Dijilah swap had not happened, the other risks over here somewhere would still have occurred. And the central risk management desk would have had to have dealt with that by the same process. By finding another transaction to offset it, question mark, yes, or externally hedge it. Now, X hypothesized, because of what she said previously, because they're already matched, there will be no other internal transactions, and the only option left is externally hedge. And it's telling that the witness only thought of two possibilities: another internal match, well, the fact that they netted off excludes that, or externally hedge it. She didn't say speculate. Mr. Young had to remind her that speculation was a possibility, but in my submission, speculation is not a realistic possibility. So going back to paragraph 9, in my submission, the first stage is clearly established on the evidence before the judge, on questions actually asked and evidence actually given, that but for without the breach and therefore without the internal role, they would have had to make a decision. Now, I accept that it wasn't then put, and the decision would have been to externally hedge, and the external hedge would have been a loser. And really, the question in this case comes down, in my submission, both aspects of it: the application to be allowed to run it, and the rightness or otherwise of the point, if I am allowed to run it, is twofold. Firstly, is the evidence there? Are the findings there which entitle me to invite you to say they would have externally hedged? And secondly, sorry.
Is the evidence there and are the findings there are two quite separate questions?
Yes. Well, is the evidence there of what they would have done without the internal role? And the second is it unfair to my learned friend on the basis that he could have done something different at trial?
Well, you'd rolled up in the first of those the concept of findings by the judge and evidence which was before the judge.
Yes.
And they don't have the same status.
They don't. No. And I'm inviting...
And you're inviting us to say that the judge's findings are sufficient, or that the evidence was sufficient because it was uncontested?
The judges, but both, my lord. But it's an inference from just what's in the judgment that they would have externally hedged. Because of his findings, that the purpose of this, the purpose was to, the purpose of VISTA was to inform them as to what hedging they needed, and because he also found that the policy was external hedging. And can I show you that part? That's core bundle page 96. It's essentially 176 to 178. So I'm going forward in my submission. At 176, page 96 of core bundle tab 8. Much of the focus of Mr. Beckett's evidence was on how the trader responsible for the initial deal would see matters, and so on and so forth. This reflected Mr. Beckett's view that there was no fundamental difference between an internal and an external hedge in relation to a particular portfolio or a particular trader's book of business. That may be a correct way of view it, but when it comes to consider the position of VITOL as a whole, it is not. Now, that is the conclusion which I contest. Mr. Beckett and internal Rhine also placed weight on what VITOL has said publicly about its attitude to risk. They relied on a public statement which VITOL had explained that it aims to, and so on and so on and so on, hedge directional price risk where possible. The quote ends in the 6th line. And then the Sunday Times. 178. Mr. Beckett suggested it was improbable that VITOL was saying such things publicly, but failed to implement such a strategy which he suggested was the burden of VITOL's case here. However, it was not VITOL's case of evidence that it failed to implement such a strategy. What was said publicly was entirely consistent with what VITOL said it did and what the evidence demonstrated it did in relation to this transaction. And then the reading too much into the position, VITOL's publicly stated position was not that it externally hedged every transaction individually. Its approach to addressing risk involved a detailed and sophisticated system which may have included but was not confined to external hedging. Now, on those findings, and given, it might mention that was acceptance of the evidence of their policy, and he said it didn't matter because they did it, and it was accepted that they therefore had a policy of hedging in my submission, and he finds that doesn't mean externally every time. That means applying the detailed and sophisticated system, which may have included but was not confined to external hedging. Now, it is an inference from what the judge says that without the internal hedge, they would have gone to that external hedging. The sophisticated system at 178 we've seen is either internal matching stroke hedging or speculation or external hedging. But when the policy of external hedging is applied where possible, as the judge finds in 177, he finds, because he quotes Mr. Becker, and then he says they complied with that. In my submission, the necessary inference is that they would have externally hedged from just this. But I do go further to say, if you look at Miss Bosley, her evidence, then it is there explicit that they would have had to take a decision. They were saved from taking a decision by the internal role. And although she mentioned speculation, the only decision realistically available within the policy was to hedge externally. Second issue, so the answer to my Lord's question is I say it can be inferred from the very findings of the judge. If I'm wrong about that, it can be inferred from a combination of the findings of the judge and express evidence given by the other side in the trial. Now, fairness or unfairness, my Lord, in my submission, if the argument that I am now making had been made in closing before the judge, there could have been no objection to it. VITOL chose their witnesses. They chose an appropriate expert and a risk manager. It transpired that the risk manager disavowed any ability to say what the ultimate external hedging stroke speculation decision would have been. But he did say in his evidence that it was either internal or he said they may go externally. But perhaps I should show you that. I've skipped over this. It's paragraph 43 in the supplementary bundle, tab 1, page 11 under the heading summary. VITOL's internal risk management procedures.
So sorry, which page are we on?
11 of the supplementary, 43 of the witness statement.
Yeah.
Internal risk management procedures involve pooling and offsetting risk from many different transactions in different groups and between different subdivisions. Only after the net effect of this process has been considered would external hedges be entered into, and then only in respect of the net position of VITOL. Now, my submission is that if you take out our breach, there would have been a net position, and on this evidence, the net position would have been externally hedged. Now,
I'm sorry, I'm not understanding the point you're making on this.
yeah, I'm ultimately making the point that nothing at trial could have gone differently had the point been put in the opening skeleton, for example. Because that was his evidence, and that is the evidence. That's all the evidence that we need, coupled with looking through the numbers that there was an
So
external.
you say this amounts to his evidence that there would always be an external hedge.
If there was a net risk, and not always is too high, but probably, I would say.
But he's making a slightly different point, isn't it? That you don't hedge individual transactions.
Yes.
You hedge the book, if you hedge at all. He's not saying you do always hedge the book.
Well, not always, but probably hedge the book. And that follows on from the policy that we've seen.
Well, I understand you say that we can get that from elsewhere, but I'm not quite seeing how you say that's what Mr. Smith is saying here.
I see that. And it's fair to say that he says earlier on that we may hedge. I think I mentioned that. But I do say in his summary, only after the net effect of the process would external hedges be entered into, and then only in respect to the position of VITOL SA. I accept that that doesn't mean always, but I do submit that represents normal practice, and that's how that ought to be read. And so my basic submission on that's the they would have externally hedged rather than speculated. So the building blocks are without the 7-day delay, there would have been an opposite risk which was unmatched. That would have meant a net exposure, and the net exposure would have been externally hedged. Those are the building blocks, my lord. And I've cited the evidence I've got, paragraphs 11 to 15. I essentially make the submissions that the external hedge would have replicated as close as possible the internal hedge, but from the point of view of the position that was taken up by 101 on behalf of the rest of VITOL would have been a loser, and the best evidence of how much it would have lost is the actual loss that 101 made on the internal hedge, and that's where my leeway point comes in, although it's not. It's saying that that's conservative for one reason, and that assists you to say that it's not wrong for another reason. Now, my learned friend, so I think on this side of things, and not the res inter aelius acta side of things, I think that is all I wish to say about the point itself and the lack of unfairness in allowing it to be run. But I think I ought to make some submissions about whether it's open as a formal matter, or whether it's within the grounds of appeal. So, my lord, my submissions on this are that the way it's argued now is within the pleading, because the pleading covers any any gain from hedging arrangements. And these can be called hedging arrangements, and any gain includes avoiding a loss. So it's within the pleading, but certainly not particularized in the way that one would like to see. It's also, my lord, within the grounds of appeal, if that is read in context, and that is in the core bundle, tab 2 at page 13. Now, we have applied to amend this, but before you come to that, and that application, as it were, I have moved or do move now, as well as the application to be permitted to rely on the skeleton. But the ground of appeal is quite simple. The learned judge erred in holding that the internal swaps entered into by VITOL, as found in para 127 of the judgment, in consequences of Rhine's breach of charter, were not lawfully relevant damages. Now, in context, that it's clear from the judgment that it was not the original internal swaps that were in consequence. That can only mean the swaps that were otherwise called the roll. And so one of my amendments proposed is to insert the words rolling of the. It's not necessary because the rolled transactions were swaps, and they were internal, and they are the only swaps that this can mean because they were the only relevant ones in consequence. So if necessary, and if one is being literal, one could read swaps there as meaning only the original and not the ones resulted of the rolling, but I don't think that's material. It effectively must mean rolling of the swaps, as found in paragraph 127. Now, if you look at paragraph 127, it's about something completely different. It's about whether there was a delay or not, whether the delay was a breach. So that is an obvious clerical error. And if you accept that rolling of the internal swaps is what the internal swaps means, then paragraph 127 can only mean paragraph 61 to 64. I could probably be a bit more precise than that. Probably 61. And that, in context, that is what that ground of appeal must mean.
But the amendment goes a bit further than that, because your amendment seeks to delete the second sentence.
Is it?
Doesn't do it first, it just omits it. The amendment does make the changes you've just suggested to the first sentence of what we see at page 13, but it then silently drops the rest of that on page 13, which is what we have to use to interpret what the original grounds of appeal meant.
That's a mistake. Yeah.
Right, so that should still be there. And the ground for which leave was given was the one of proper analysis in law and of the system. The internal swaps, that's the 645 to 101, were not lawfully or materially different from external swaps included with third parties, i.e. they were identical to entering into an external swap, 645 just doing an external swap. Now your book hedge avoided,
Is that so?
your book, well, isn't that what it's saying?
On a proper analysis in law, VITOL's just a hedging system, those internal swaps were not lawfully or materially different from external swaps. That is my submission, because they replicate an external swap. Because they necessarily mean replace.
Your submission is, once you follow them through the system, the effect of the system is an avoided book hedge. That's the new case. And that isn't what's being said here, which is not terribly surprising because it wasn't the point that was run at trial. So Mr. Young wouldn't have been seeking permission to appeal on that ground.
But it is within those words because my submission now is that the internal swaps were not lawfully or materially different from external swaps concluded with third parties because they replaced them. Or avoided the need for them.
Or the need for something equivalent.
Yes, yes. And were such as to render VITOL's recoverable loss 802. That is exactly what I'm saying. I mean, if you like, I should give particulars of were not materially different from the external swaps, brackets, because they replace what you would others have to do, something like that. And so my submission is that I have got permission that covers this point. It is merely a question of arguing it differently. Which I submit should be allowed unless my friend is well, I think what I would say is unless the trial would have gone differently had the point been argued. Now the first time this point would have had to be argued is probably the closing submissions. But it could have been argued in opening, and I haven't, I'm afraid, I wasn't there, I haven't got the opening. But I think we can probably accept that the opening submissions narrowed the pleading down to a version which did not explicitly include the way I have now argued it. I mean, my submission would be that in the absence of request for particulars, one wouldn't have to do that. And in my submission, my first point is that it is not a new point, not raised at trial. It is within the points that were raised at trial, for which leave has been given. It's merely the question of differently arguing a point that was raised in the pleadings and therefore at trial. The point itself, which is internal is not different from external, and made them a credit, is the same point now. So it's a question of a different argument of a point already, and if that's right, I'm not in the new point territory. If I am in the new point territory, my learned friend relies on the white book at page 1879. He sent me very kindly that by email. I don't know if it's available to your lordships.
Well, are these the passages that were sent with the
crane
intersolicitor? Yes.
Yes.
Well, that's all pretty familiar stuff.
Yes.
May I have one? Thank you.
Surprising, you may think, we do not anymore have up-to-date white books in court.
I'm very surprised my learner junior does, because he's got it on screen. and
I've got this, so don't worry.
I don't dissent. If we are in the new claim territory, I don't dissent from Lord Justice Haddon Cave's summation in Singh. The appellate court will be cautious. Well, the appellate court will be cautious about allowing a new point to be raised on appeal, and I certainly do not dissent with that. I'm making such detailed submissions in the assistance of caution. Appellate court will not generally permit a new point to be raised on appeal if that point is such that either it would necessitate a new evidence. Now, in my submission, not so, because the trial was fought on the basis of the evidence that was there, and there is no new evidence that could usefully contradict the evidence that was given there and the findings of the judge. Or had it been run below, it would have resulted in the trial being conducted differently with regard to the evidence. Now, my submission, not so there either, because my learned friend, what we rely on is material from my learned friend's own witnesses about the internal workings of VITOL. He couldn't have cross-examined any differently my witnesses who don't know anything about the internal workings of VITOL. The experts were examined about questions such as, do you match internally, do you speculate, or do you hedge? And in my submission, nothing material could have been done differently at trial had this point been run, possibly in closing, but certainly in opening.
Did your expert not proceed on the basis that there would be some internal speculation, certainly as a matter of timing?
Yes.
That pretty coloured chart, that seems to...
What it was
Sorry,
to... I don't know. I think
identify the document.
I think it was to do with... It might have been to do with the weekend. He criticised them for leaving the position unhedged over the weekend, I think.
No, what I had in mind, sorry, let me just put it to you so you can deal with it. We've got it in two places, but it's part of this, Beckett's second report behind tab 12. Is that right? Yes, page 161. And I'm only pausing there because I think we've got a clearer blown up copy of it behind tab 13 at page 176. With some blue boxes, some grey boxes, and some orange boxes.
$176 or so. Yes. That's the chart, the organisation chart, is it?
Yes.
Yeah.
which has a box for unallocated pooled hedges.
Which go into a risk management process. So they get hedged. Or you can decide to put them into the speculative portfolio to the right.
This, as I understand it, is his understanding of how VITOL worked.
Yes.
Which had a speculative.
It had a speculative book, yes. Yep. I entirely accept that, Lord. And
But the whole underpinning premise for your argument is that this wouldn't have been part of the speculation.
Yes, because it requires a decision from on high, and they use different instruments. That was part of the joint memorandum. If I can just show you that. And this perhaps the way I can do this better is to go to the supplementary skeleton and take you to paragraph 12, where I think these references are. VITOL would not have run a speculative position, and then I make the points about that they rolled the swaps in the first place. It would have been speculation, and that was against the policy. That's B. And then C is the one that I think addresses your lordship's particular point. The traders sometimes speculate, but if so, they would do so as part of a well-defined strategy using liquid derivative, that was Mr. Beckett's word, or trading, that was Ms. Bosley's word, instruments. And that is in the joint memo at tab 11. Paragraph 40, page 150 to 151. So the expert...
Item 15, did you say?
14. So the experts did consider speculation, and what they said is trading companies often speculate on both flat prices and on price differentials, and that was agreed with qualifications. And MB, who is Rhine's expert, said generally all trading companies will take some measured speculative risk on prices and their interrelationships. It's far more common to speculate on spreads than flat price, that is, speculating that the market will move in a certain direction. In my experience, where a trader does take a speculative position, it will be part of a well-defined strategy agreed with a wider team with separate deal numbers and include liquid derivative instruments and not physical cargoes that are unhedged. Speculative position would not be mixed within a Vista hedged physical deal that is part of a separate strategy for the simple reason that it would be confusing. Nobody wants to confuse how profits are being generated in what strategies and by which traders. And then over the page at 151, Ms. Bosley, the other side's expert, says, generally speaking, trading companies do take measured speculative risks when it suits their price market view and risk appetite. On other occasions, they may decide to identify a profit between a physical purchase and a sale and lock in that profit by hedging, i.e. arbitrage. It is in my experience that when such companies decide to take flat price risk, i.e. the next move in absolute prices in general, they tend to do so using a liquid trading instrument such as future swaps or options contract, using one of the benchmarks such as Brent or WTI. This allows them to get in and out of positions quickly if they change their mind. But the whole point of consolidated central risk management is that hundreds of disparate risks, whether for Vista or not, can be considered in the round and used to inform the entity that is considering taking a speculative position, whether it is overall long or short of a particular price risk, and it's not confusing. Now, in my submission, the agreement that they would use liquid instruments, and that means not ultimately on physical cargoes, that suggests that the particular problem created here was delay in the pricing date on a physical cargo. And it's completely different to enter into a company-wide speculating strategy, and that explains that part of Mr. Bartlett's report. And as I say in 12C, following on from A and B, a speculative decision on a risk created by a physical risk in effect can be ruled out. And I do rely in this context, paragraph 13, on the passage I already showed you by Miss Bosley, where when going through the options, she forgot to say speculate, and Mr. Young had to remind her that speculation was a theoretical possibility. He didn't use that word. But I submit speculation is so unlikely, given their policy, that it would not have happened as a response to this particular circumstance, which is not part of a company-wide speculating strategy. So, yes, my case does depend on it being inferred from the judge's findings about the policy, supplemented, if permissible, by the agreements of Miss Bosley. But in my submission, you can rule out speculating on this risk being the unhedged physical, or created by the unhedged physical risk here. I was in the authorities, so I think I ought to say a word about Crane.
And does that submission depend upon being able to identify this risk at the book level when you're deciding
No.
whether to hedge?
No.
Why not?
It only depends on identifying that without this risk, without the physical risk of 7 days delay increasing the Dijilah price, all I have to establish, as Mr. Smith said, is that would have created a net exposure to that extent.
But at the book level, it might look like a derivative, exposure on a derivative, which is exactly the kind of instrument on which they might speculate. That's what the system is doing.
Well, the system is telling a commercial analyst whether they are at risk or not to price movements. That's what the system does. The commercial analyst then decides, can he find matches within the system? And on this occasion he did. But if he couldn't, then it goes up the chain to somebody to decide whether to speculate on the physical book by transferring it over to the speculative book. And so what would have to happen, to use your lordship's beautiful diagram, is that
Not my diagram.
117,
Not even sure I'd say it's beautiful.
yes, 13, tab 13.
I know the diagram.
Yes, 176. Yeah. Black and white. What? Well, firstly, I'm not sure it would be an unallocated pool hedge. Let's assume that other side of it is waiting to be matched with a physical deal or move to the speculative portfolio. Well, my submission, actually, that doesn't quite match ours in my submission. But if it does, then there has to be a risk management process and a positive decision to transfer it to the speculative or derivative portfolio to the right. And in my submission, that after you've gone through the...
My difficulty is I don't understand what you mean by it. Because...
The net surplus, the net risk.
Well, exactly, but the risk may be, because it's not going to be in the same form, the risk may be, look like exactly the same as the derivative risk, which is just the kind of risk on which they may speculate.
Well, but only...
I'm not quite understanding your...
But only if there was a as it were, company-wide strategy for speculating, whereupon they would use one of the liquid instruments. But I submit that the experts' agreement that they would use liquid derivatives is different from a risk emerging from the Vista system itself based on thousands of physical transactions. That is a different, in other words, what Vista spits out at the end of its doings is you're long or you're short, or you're exposed to a risk of a fall in the market, as I submit is this case. That isn't a derivative, even though there might be lots of churning within Vista. That is the Vista's process of assessing their risk on physical, as I understand it. But I'm not. Well, I think that's what Mr. Smith, how Mr. Smith described it. Anyway, it's certainly what happened in this case, and the opposite risk will derive. I think it was said the opposite risk will derive from a number of other physical transactions within VITOL. I think the Vista system is one for managing physical transactions. I may have to come back on that if I may have not pushed back sufficiently when your lordship said the Vista system would crunch derivatives as well. I mean, it would record them, but and it would record particular hedges on the particular physical, but it wouldn't produce, if I might call it, the raw material on which a speculative decision would be made unless it's treated as an unmatched pool hedge.
Well, you may be right. You may be right. But I would myself find that slightly surprising, that if you're going to put derivatives into your pot, where the derivatives derive from physical cargoes, you're not going to take account of those. I referenced all the other derivatives you might have on your pure derivatives. You would have thought that they would be put into the same mix. But anyway,
I would have thought otherwise.
We don't really know, do we?
Well, we do, because the experts have said there are effectively two books. There's a speculative book over there and a physical book over here. And these risks are all derived from the physical books, but you end up with a number which says we're net exposed to fall. And the expert evidence is, if you were over in the speculative book, you would use liquid instruments to speculate. But here you would be using the result of physical instruments, the net result of many, many, many physical instruments to speculate. And in my submission, and I also add, there are those other references that indicate, at the very least, I mean, his lordship, the judge below, identified that there was the policy of hedging at that paragraph, and purely as a matter of argument, and not as a matter of any evidence that could have been got had this been raised on day 1 or day 3 of the trial, nothing could have gone differently, because I'm still addressing the should I be allowed to argue it, although each argument has a knock-on effect on whether it's right or not. And just finally, before I move on to res inter aelios acta, there's the Crane decision. That was a case in which a new point, what was avowedly a new point, had to be was refused on the basis that it did require new evidence, and that was answered by a submission that one could restrict the evidence or the party should be restricted to the evidence that was at trial, and that was held to create potential unfairness, not in a way that I submit arises here. But what I would like to do is, in other words, it's a case on its facts and not as the principle. Yeah. What I would like to do is show you the Paramount case, the Privy Council, which was taken by Mr. Justice.
Well, now, sorry. What is?
Sorry.
This is still going to the question whether you should be allowed to take the point.
Yes, it's my final point on that.
Well, all right. And that will then make a natural break.
It will.
Well, then let's look at that.
And I'll be very brief on res inter. So it's Crane, and it's the case that was sent forward and just now recently done. And I say it's a case on its own facts, and I might have to reply on this, but paragraph 12 in the judgment.
Sorry, have we got it?
Crane, which was...
Oh, we're on Crane.
Crane?
Yes.
I thought you were talking to the case on Paramount. I thought Crane, you'd made your submission. That weren't going to take us to. It was based on its. I'm in a muddle. What are we talking about?
Okay, it's Crane. It's not Paramount. Paramount comes in under res inter alios acta. I would simply invite you to look at paragraph 12 within Crane, and material facts in paragraph 46. Sorry, I'm losing it a bit. It's the decision of Crane, which quotes the decision of Paramount.
Oh, I see.
Sorry.
Well, at the moment I did print out Crane. I don't seem to have it with me, but no, I probably.
I just make the submission.
I found it. Yes, okay.
I just make the submission on Paramount that it stands for the proposition. So it's not just a question of simple fact. It stands on the proposition that, and this is para 46 of Paramount within paragraph 12 of Crane.
Yeah.
Paragraph 46, the case was for an assumption that if it had been known, the plaintiff could have adduced evidence. The Lordships consider that the plaintiff cannot complain about being misled about the evidence they would need to adduce at the trial. On the pleadings, the whole question of the contractual liability and the construction of the agreement was an issue. So,
yeah.
So a party facing a new point cannot complain that he would have adduced further evidence if it was an issue in the pleadings, and that is a principle that applies here in my submission. And it would have been open to the meat board without any amendment of the pleadings to put before Heron J the argument upon which it now relies. So also here. If Mr. Young had popped up in closing and argued this, then it would have been open to him because it's open on the pleadings. And in any case, the surrounding circumstances were exhaustively explored at trial. So here, my lord, and their lordships are unable to imagine what facts would be unearthed, which would lead to a different conclusion. So the principles there are, if it's open in the pleadings, if it could have been asked at trial, and if the circumstances were exhaustively, then even if a new point, it should be allowed. That's my submission on that. Sorry, I had intended to be done by now, but...
You've had a bit of interruption.
Yeah. How much longer are you likely to
20 minutes.
expect to be?
Hopefully 15. Allow 30% for questions.
Let's say, well, that's not put you in any difficulty, Mr. Toms, obviously.
Thank you.
Very well. 2:05.